via HMRC self-assessment system.
To a particular tax office, but not to a particular officer.
No, and that is what Rogers and Shaw says as well.
Okay, thank you.
The other point, and again trying not to start too many hairs running again, is that section 1.4 of the CRCA 2005, which we don't have in the bundle, does say that commissioners act on behalf of the Crown. And there is a governance document which refers to HMRC as being a non-ministerial department. That may or may not be helpful, but just to round off the point.
Ms. Chowdhury, I think you said something before the short adjournment about how one proceeds in relation to judicial review. Yes. That would be against the commissioners? I can't recall what you said.
Yes. So if, for instance, you want to bring an action against HMRC, which lies in judicial review, then you would bring your action in the name of the monarch on the application of against the commissioners for HMRC, HM Revenue and Customs.
Thank you.
And just emphasising the point, it's a public body. Now, moving on to the respondent's notice point, which you will have seen is that HMRC contend the Upper Tribunal erred in interfering with the FTT's conclusion that the Section 8 notice was validly issued on the basis of the evidence before it. And in particular, it found that the FTT had erred in holding that there was sufficient evidence of human input. And as you will know, this point only arises if you're against me on Section 103, and of course the FTT decision was issued before Section 103 came into force. Yeah, you'll have heard my learned friend refer to how in this particular case the appellant had put HMRC to proof in relation to the validity of the notice, and evidence was served, albeit late, but no objection was taken to the late service of that evidence. If you want a reference to that, it is in the agreed chronology on page 58 of the core bundle. We do need to look at the FTT decision to see what it actually decided and what it had before it. And this is at tab 10 of the core bundle, starting at page 150. Paragraph 114, which is, at that point, this was the third issue. Now, it starts there and broadly sets out the party submissions in relation to Rogers and Shaw. But we can skip forward to page 152 and the section headed discussion, which starts just above paragraph 125. And in paragraph 125, the FTT agrees with my learned friend that it cannot rely on evidence given to the Upper Tribunal in Rogers and Shaw. But we then see in paragraph 126 that its conclusion, and in fact what it refers to as the only reasonable conclusion from the evidence before it, was that HMRC officers had approved and authorised the issuance of notices to file in 2012 to 13. And that is the point, paragraph 126, which is the focus of the Upper Tribunal's criticism. Paragraph 127, it refers to the meaning of officer as discussed in Rogers and Shaw. And then the key parts of its reasoning are paragraphs 128 to 130. And in fact, my lady, you'll see there that it too takes the view that it can refer to an officer as just a staff member. Paragraph 128. Paragraph 129 sets out its main findings, and I'll come on to those. And then paragraph 130 postulates a couple of alternatives. Paragraph 131 deals with the statute as always speaking point, which I'll come to at the end. The fourth issue is the validity of the penalty notices, which is dealt with in a broadly similar way. In this case, it sets out the legislation and the submissions. At paragraph 138, there is a passing reference to the case of Hansard, which my lord may be familiar with.
I don't remember it at all. I assume that's me.
That's good. That's because it wasn't you, obviously.
Well, it isn't in the bundle and we don't need to refer to it again. And then paragraph 139. And the discussions and 140 just set out more of the submissions, and then the discussion is set out in one page, page 155, from paragraph 141 to 146. And again, it comes to the same conclusion that the notices refiled were issued by the computer in accordance with the programme as authorised by HMRC staff. Now, my submission in relation to the respondent's notice point here is that when reversing the FTT's conclusions on these points, it went beyond the role of an appellate body. And I picked this up in paragraph 21 of the Upper Tribunal's decision on page 72. And it's referring to, in particular, paragraph 21 is referring to paragraph 126, which we've already seen, and says that this was not a conclusion it could properly draw from the primary evidence and amounted to no more than speculation. And makes a similar point over the page at paragraph 22. And as for the penalty assessments, and I think, sorry, paragraph 22 seems to be a reference to paragraph 129 of the FDT. As for the penalty assessments, it again comes to a similar conclusion, and that's paragraphs 26 to 29. And in fact, sorry, paragraph 30 as well. Mm-hmm. Now, as to what the role of the Upper Tribunal was, I refer you to the rather well-worn passage in Fage and Shabani, which you'll have seen before, but not Lord Justice Lewison's points, but just what comes before them. And this is paragraph 114 on page 230 of the Authorities Bundle.
So not the first and last night of the show.
Or island hopping, dress rehearsal, etc., etc. But
first and last night of the show is the best line. Sorry, which is the page?
It's page 230. And it's just it's the start of that paragraph. Paragraph 114, where it makes the point that your appellate courts should not be interfering with findings of fact, and not just findings of primary fact, but the evaluation of those facts and to inferences to be drawn from them. Now, the reasons why HMRC submit the Upper Tribunal made an error of law in reversing the FTT's conclusions on this point is it appears to be based on the fact that HMRC's evidence did not show who had authorised the issue of the Section 8 notice. Now, they make the point, and we've referred to this in passing already, the computer must have been programmed by someone. And it is implausible that the notice could have been issued without the authority of HMRC. And I'll come on to that in a moment. Bearing in mind that HMRC then sought to impose penalties and to defend the assessment on the basis of that notice. And it was recorded on their internal systems. So, first refer to what the hurdle we had to meet based on what is said in Rogers and Shaw, and then look at what the evidence was before the FDT. and to explain why I say that the Upper Tribunal went too far. So if we turn to Rogers and Shaw again, which is on page 176, and this is paragraph 51. And in this paragraph, the Upper Tribunal is making the point that where there is a challenge in relation to a Section 8 notice, it is for the FTT to determine whether the evidence is strong enough to discharge HMRC's burden of proof. And makes the point that evidence to the effect that HMRC systems record a Section 8 notice as having been sent is on its own relatively weak evidence, since it does not demonstrate that the notice was actually sent. It may not demonstrate the address to which it is sent. And it makes the point that may nevertheless be sufficient if the taxpayer is not disputing having received a notice to file. There's a reference then to Edwards, another case which my lord may or may not remember, but which we will come on to, which refers to a taxpayer may be disputing having received a notice, in which case the tribunal may have to look for further evidence, such as whether or not the notice was actually sent to the taxpayer, or whether the taxpayer tried to submit a tax return. Now, the Upper Tribunal has this in mind when, at paragraph 20 on page 72, it refers to HMRC's evidence as being weak. Now, the evidence before the FTT, which is referred to there, and was before the FTT, is referred to in the FTT's decision at page 149 in paragraph 108. And so there's the first 2 points. It's the self-assessment return summary, which showed that a full return had been issued to Mr. Marano on the 6th of April. If it's possible to have the supplementary bundle open at the same time, I can show you where that is. It's page 75 of the supplementary bundle.
Mm-hmm.
Sorry, give me that page again.
It's supplementary bundle, page 75, tab 20.
This is what, a screenshot of a computer page, is it?
Pretty much, yes. So if you look for, it's referred to as the return summary. So what happened in that year? And I think you'll have seen the point made a couple of times where it says return issue date 6th of April 2013. That is almost a generic date. But nothing really turns on that in this case.
So the only evidential purpose, if you say the 6th of April 2013 is a generic date, is the fact that it says return status issued.
Yes, for that year.
Yeah. Mm-hmm.
The other piece of evidence the FTT refers to in paragraph 108 is the microfiche evidence, which is on the previous page, page 74. Which probably on its own, well, it has a name and an address. but it's probably more helpful to look at what the explanation of the microfiche on the previous page, page 73. And so that's the evidence from HMRC's internal systems referred to by the FTT, which show that notice was sent, referred to as sent, all quite consistent. Now, Rogers and Shaw tells us that's not enough, but the FTT then also refers to the correspondence between HMRC and Mr. Marano's agents regarding his outstanding return. And at paragraph 109, it also records that his evidence in cross-examination, where he accepted that he had received the return. So taking it together, we have evidence that the notice was actually received, an electronic record, the microfiche, a computer printout or screenshot confirming it was issued, and then engagement between the taxpayer and HMRC, which proceeds on the basis that the tax return needed to be filed. Now, there was other evidence before the FTT as well, which it doesn't refer to in its decision. It is in the supplementary bundle. This includes, at page 76, what's referred to as IDMS, Integrated Debt Management System Notes, which basically record communications between the taxpayer and HMRC.
Are we in a position to take those into consideration? They're not in the FTT or the UT, are they?
No.
So I don't think we can go there.
Yeah, we can leave that. We can look at what the FTT did take into account. As for the penalties, again, we have a copy of the microfiche data at page 65.
And the paragraph that we've got in the FTT that refers to that is... Do they do that separately?
It's going to be in the 4th issue. What it's actually referred to? No, hang on.
Well, at 151, they refer to a penalty notice where HMRC have been unable to locate microfiche data.
Yes. But it refers to the lack of the microfiche data about paragraph 152. It does refer to how it was satisfied that the notice was nevertheless sent. And it's paragraph 151. Basically, there was quite a lot of confusion about the various penalty notices.
Yeah, so that's the £100 one at 152.
Might be.
And then we seem to move into
Yes.
service at the appropriate address.
Yes.
Well, at 149, by the end of the hearing, Mr. Gordon had accepted that some of the penalty notices had been sent.
I think by the Well, there is an issue about whether I think some of the penalty notices had been sent.
That still seems to be mixed up with the address to which it was sent.
Yes, so that's a separate issue.
Yeah.
Broadly, when it sets out the 4 issues at the start of its decision, it just refers to whether the penalty notices had to be issued by an individual HMRC officer. If it assists, what I would say on that is the FTT had evidence of HMRC's computer records before it, and then there is a debate about whether some of those notices had actually been received, which is a separate point.
And the business about the the penalty notices and production of them by computer programs is at 145.
Yes, this is referring again to the point about whether or not the penalties, if issued using an automated process, are valid, and using the parameters and so on. And I think quantum is then dealt with also later. There's a separate issue on quantum. And broadly, as you pointed out, that it is mixed up slightly with the 5th issue and the service, because that's where you see the reference to the self-assessment record as to when the penalties were issued, and how, as it's pointed out in 50 sub 1, the internal record of the SA penalties is clearly before the tribunal, and it says, well, but there was a debate about whether or not the £100 penalty had been issued.
Yes.
But going back to, in particular, the evidence in relation to Section 8 and the Upper Tribunal's criticism of it, which is mainly focused on, well, is this evidence weak? And HMRC would submit that it's not, and in fact the position is quite similar to that in Edwards. And we can turn to that case it's at tab 14 and page 249. So starting at paragraph 12, the Upper Tribunal sets out the material which was before the FTT. And it refers to how the records showed, it provided copies of the computer entries relating to Mr. Edwards' self-assessment record for the tax years in question. and when notice to file returns were issued and their due dates, as well as the dates on when the returns were filed. And you see there again a reference to the 6th of April being the date. But notices being issued in batches throughout the early part of the tax year. Now, paragraph 13, it refers to a copy of the self-assessment notes, the various actions taken by HMRC in relation to Mr. Edwards' self-assessment account. And paragraph 14, the first line refers to the material demonstrating the address held on file for Mr. Edwards. And as to what the Upper Tribunal made of this evidence, whether it was sufficient, for it to find that the notices were sent to Mr. Edwards, paragraph 56 on page 258, it says that, well, that would not have been sufficient on its own, but there was other evidence. So including Mr. Edwards' oral evidence and the entries in HMRC's records recording interactions with Mr. Edwards, and particular sending of penalty notices and subsequent communications, and the fact that he did not dispute receiving the notices. And so broadly, let's admit that, contrary to what the Upper Tribunal says, this case is actually quite similar to Edwards, that in addition to the internal records, there was other evidence available to the FTT on which to base its conclusions. And it was entitled to reach the conclusion that a notice had been issued with the authority of HMRC and sent to the taxpayer. But it seems that what the Upper Tribunal's decision comes down to, in particular when it's looking at this case and, say, Rogers and Shaw, is the one difference between the two cases is that in Rogers and Shaw you'll have seen there's a reference to the witness statements which refer to the process by which HMRC determined the criteria on the basis of which notices to file were issued. Now, I'm not going to pretend that there was similar evidence here. It wasn't. It's not in the supplementary bundle. It's not referred to by the FTT. So it really comes down to a question of whether that was sufficient for the Upper Tribunal to go behind the FTT's conclusion on this issue. And before I finish on this, it was the point I make in my skeleton as well, that there is almost a strange tension in the Upper Tribunal's decision when it's dealing with the 2 points in relation to Section 103 and the evidential point. Because if we look at paragraph 48 on page 86, which is when it's this is its conclusions in relation to the Section 103 points.
Which bit?
So the last bit, as to whether or not the notices had emanated from HMRC. It says that it would have held that they were. And it is inherently improbable that HMRC would have a record on its own self-assessment system of notices having been issued and of the correct amount of the penalties assessed, unless HMRC issued the notices, which is a point we touched on this morning. So turning then to the criticisms of the FTT's conclusions made by the appellant in his skeleton argument, and this is paragraph 52 of the skeleton, and I do deal with these in my skeleton as well, so I'm going to run through them fairly briskly. The first point is, well, there was no evidence before the FTT that the issuance of the notices was recorded in HMRC's computer systems. Well, and they say, well, all we know is that Mrs. McGovern, who produced the witness statement on behalf of HMRC, had access to a microfiche record. But she does explain in her witness statement how a microfiche record is maintained in all cases where a notice to complete a tax return is issued by a computer. I've just taken you to the notes on that. If you want the reference in her witness statement, it is page 50, paragraph 21 in the supplementary bundle. It basically repeats the point made in the guidance. Secondly, the appellant makes the point that, well, at least by 2016, a lot of the sending of HMRC notices was outsourced to a third party, as we saw, as was discussed in Rogers and Shaw. And my response to that is that even if the notice is issued by a third party, that party would have received instructions to issue the notice from HMRC, more particularly HMRC officers. I mean, if it wasn't issued with the requisite authority, how would HMRC know about it, or let alone take any action in respect of it? And the third criticism is the one I've already touched on, about the absence of evidence about the parameters and machinery in existence at the time regarding the approval and authority of the issue of notices. To which I would say, but the evidence before the FTT shows that a notice was issued by HMRC and would have been issued with the requisite authority. There's a criticism of the records held by HMRC. Well, we've seen, and the FTT saw, the microfiche record and the self-assessment record before it. And that's then coupled with the evidence it hears from Mr. Marano. And I think the fifth criticism is again on the outsourcing, which I've already addressed. That doesn't really take it much further, because any contractor would still receive instructions from HMRC. There is a specific criticism made about where the tribunal, the FTT, refers to how, well, there's no suggestion here that, say, the HMRC's computers have been hacked or they were controlled by artificial intelligence. Now, the appellant says, well, here it's trying to reverse the burden of proof, to which we submit, well, no, all it's doing is just checking. Is there another explanation for how these notices came to be issued and sent to the taxpayer? So, in essence, HMRC submit that the FTT was entitled to come to the conclusion before it, which it did on the evidence before it, that the notices at issue in the appeal were issued with the approval and authority of HMRC and were valid, and that such conclusion was entirely reasonable, and it was based on proper inferences, and the Upper Tribunal was not entitled to interfere with that finding. My final point is the point on the statute is always speaking. Now, you'll have seen the FTT considered it unnecessary, and the Upper Tribunal didn't refer to it at all. I'm going to refer to it, but very briefly, because my submission, it is an alternative way of coming to the same conclusion. Now, you will have heard, it was referred to this morning as well, that what it does is provides that legislation ought to be construed to take account of changes in technology or otherwise since that legislation was first enacted. There has been one development since the Upper Tribunal hearing, which is the Supreme Court's decision in News Corporation UK and Ireland, which considered the principle at some length. This was to do with whether or not an electronic newspaper ought to be subject to the same VAT treatment as a printed newspaper. And the section in which sets out the principle starts at paragraph 27. It's in the authorities bundle on page 319, tab 16. And you can see it's paragraph 27 introduces the principle, and this is the majority. Lord Legatt put forward his own reasons. He agreed with the conclusion but had his own reasons for coming to his conclusion. And so paragraph 28 refers to it being a well-established principle and refers to various cases, and then paragraph 29 explains what the principle is. And refers to how it will generally apply unless there is something in the words which suggests that it not ought to. And paragraph 30 in particular just sets out how it prevents statutes becoming outdated.
But how does that really apply here?
Well,
tell me.
Well, all I would say is that it shows that Section 8 was introduced in around 1994, so computers were well on the horizon then, but large-scale automated processes, not so much. So matters have moved on because now that is how HMRC issue a large number of routine notices with more automation, widespread outsourcing. And so based on that principle, you could say that we could get to the same result just looking at the words of Section 8. However, Section 103 may make that all redundant. It also does raise the question of if and when we do get to the point where HMRC have computers which can issue notices by themselves, whether it would apply. But that is not a question we have to deal with today. And so my only point in relation to that is an alternative way of reaching the same conclusion. But as you can see, both the FTT and Upper Tribunal did not consider it necessary to rely on it. Having reached what we would say is the right conclusion, albeit for different reasons, bearing in mind that the law had changed in between.
If the 1970 Act was still speaking, there would have been no need for Section 103.
Well, we would say that it was still speaking, and Section 8 was speaking, but bearing in mind the number of challenges and the effect it was having on resources, but new legislation was brought in to deal with the issue.
With a purpose.
Indeed, yes, precisely that purpose. May I just check if there are any questions in my screen or behind me? I see lots of shaking heads behind me, so unless you have any questions, those are the submissions.
Thank you very much indeed. Mr. Gordon.
My Ladyship, I shall try to deal swiftly with my reply on the matters of our appeal. And to do so, perhaps it's helpful if I can make good my promise to Lord Justice Nugee about examples of authorised officer. And I ambitiously said, Schedule 36 to the Finance Act 2008 has references to it. I then pointed to possibly an unhelpful provision within the schedule. I can actually take you to more helpful provisions within the schedule. I realise that the court doesn't have copies of this, and I can make good this in due course if the court would like. But within the schedule, there are 5 types of information notice that HMRC can issue.
Remind me again so that I can write the note.
Finance Act 2008, Schedule 36.
Thank you.
under paragraph 5 of the schedule, there is it's headed a power to obtain information and documents about persons whose identity is not known. I don't think I've ever seen one of these in practice, but I'm sure they do exist. And subparagraph 1 says an authorised officer of Revenue and Customs may, by notice in writing, require. So that is a provision that is limited to an authorised officer. Paragraph 5A provides a power to obtain information about persons whose identity can be ascertained. And also that starts, subparagraph 1, an authorised officer of Revenue and Customs may by notice in writing. It's also worth pointing out, just for some slight comparison, paragraph 4A was introduced in 2021, providing for information. Revenue can now go directly to banks for information from financial institutions. Now that starts an officer of Revenue and Customs may by notice. So it doesn't look as if it's limited to authorised officers. However, within subparagraph 5, it says a financial institution notice may be given by an officer of Revenue and Customs only if A, the offer is authorised, or B, an authorised officer has agreed. I'm mentioning that just for completeness, but if I focus on 5 and 5A, where the process has to be undertaken by an authorised officer. And what I say is that following section 103, as a matter of effectively making sure there are no gaps in the legislation, Parliament has ensured that as long as the decision has been taken by the authorised officer, the process may then be effected by an unauthorised officer and or the use of a computer. And also for completeness, can I just refer the court to paragraph 59 of the schedule, where there is a definition of authorised officer. Now, my learned friend this morning has candidly confirmed that wherever the statute requires a decision to be made by an authorised officer, those safeguards have been maintained. She did not suggest that section 103 swept that away. But that is precisely what the Upper Tribunal had held. So we know, even on my learned friend's concession, that the Upper Tribunal has made a mistake in its reasoning. The point I'm making time and time again is there is nothing in section 103 that overrides the need to prove the involvement of an officer, or where appropriate, an authorised officer, where statute requires that an action to be taken by a certain type of person. Justice particularly to Lord Justice Nugee, have I answered the question? My learned friend refers to the Alum decision, and I can just deal with that very briefly. I'll expand upon it if the court requires. But my complaint is that Alum did not properly address the definition of HMRC. In one point, it sort of referred to the Interpretation Act without necessarily saying it was linked to section 103, subsection 4. But at the heart of its decision, I think it's paragraph 36, it's made a decision as to what HMRC meant, which was inconsistent with the definition further down the section. My learned friend made a point about judicial review. I'm not sure it actually gets us anywhere, but I just want to cover it off as completeness. My learned friend suggested that the HM Revenue Customs is an emanation of the Crown because you take a JR in the name of the King. I'm not sure that maybe that she didn't
That's the
say
wrong way
that.
around.
Okay. The important point, she later said after the adjournment, that all JRs are made against the commissioners. There are cases in which judicial reviews have been taken against an officer, where it's an officer's discretion. I certainly went up to High Court, I think he went to the Court of Appeal on one case where it was the officer. Doesn't really help us, but it just gives us a bit more background to this. My learned friend had to respond to some interventions from Lord Justice Nugee, suggesting that, I think, if I can remember the question correctly, is your submission that where it says an officer may do X, it is now sufficient if it is done by someone in the department? I think that was a rough phrase. And then you said, in the name of HMRC. And then you said you're not going to issue penalties if it's not a genuine HMRC notice. I think my learned friend said almost, and that is really where the crux of the issue is. It is not enough that a document is in HMRC's name. It is not enough that HMRC's system has access to the record. The problem is the outsourced function that gave rise to these records could have misunderstood the criteria or simply misapplied the criteria. The question that HMRC were asked to prove in this case was, can you show involvement by an officer? Not that this was a rogue document that someone with all good intentions has issued, not in HMRC's name. It was a question of proof. There was no proof. And then my learned friend was asked, if you're pursuing a penalty, do you need to prove it? And the response was, well, it's a resource issue. And that's precisely the issue relating to the background material that we're looking at. I'm perfectly happy to accept that it could be onerous on HMRC, and we don't know how many times it's happened, to have to prove the involvement of an officer. But that's what they were asked to do in this case, and they were asked to do in Rogers and Shaw. They were able to do it in Rogers and Shaw when they were given notice of it. They failed to do it in this case. If Parliament is persuaded that that is too onerous and a statutory presumption should be set up, well, that's for Parliament to do. It's not for this court to forgive what is a fundamental failing of the earliest level to provide evidence of the very point you're being required to prove. My learned friend refers to the joint note and the various historical cases where challenges were made. All those challenges were not to the absence, they didn't concern the absence of evidence of officer involvement. They actually looked at the very validity of a computerized process. And my learned friend briefly alluded to the case of Boscher, which I think was the first of the cases to look at this. Now, I had the pleasure of representing Mr. Boscher in the Upper Tribunal, and the point never then got fully articulated. But what has happened in the First Tier Tribunal is that Mr. Boscher was subject to monthly return obligations, because he was in the subcontractor industry, the construction industry scheme, so there's special rules for there, involving monthly returns, and he was failing to do that, and he was getting monthly penalties. And the question was whether the penalties, in the first tier, he denied receipt of all these penalties, and it was about 250 notices that he claimed not to have received. In response to that, the evidence in the first tier was there is no way he could have not received it. It is all computerized, it's all automatic, there's no human involvement whatsoever. So yes, it might be that one or two might have got lost in the post, but even the computer, it was even the computer or the robots which actually put the notices in the envelope. So there was absolutely no way that he could properly deny receiving all these things. When I come along in the Upper Tribunal, I compare the statutory requirement that the penalty has to be given by an officer, looked at the evidence, which was clearly accepted by the first tier that this was a completely automated process without any involvement by any officer, and we wished to raise the new argument. And we nearly got permission, but in the end permission was refused. So the argument then went away. But the whole point in Boscher and the subsequent cases is not, is there a lack of evidence to show human involvement? It was that the system was supposedly so automated that it had no human input. Rogers has shown us what evidence is necessary to validate an automated process. But Section 103 was not introduced to dispense with the need for evidence. It was introduced to deal with the challenge that had been made up to that stage, which was there had been an automated return or an automated process is not a process carried out by an officer. And that's why throughout the pre-legislative material, and I'm going to take you to a further example, which my learned friend's taking you to, is what was being sought to do was to protect the validity of the process. Nothing about evidence, nothing about proof. It was all ensuring that the processes were valid. So if I could just take you very quickly to the supplementary bundle, page 26.
Technical note.
This is a technical note. My learned friend took you to paragraph 1.2, but that makes the point. This long-established use of automation has been challenged in the courts on the basis that it is not supported by legislation. This was not a question of proof. The whole purpose of Section 103, and which I say was met, was to ensure that the use of automation did not invalidate the process. That is my intended reply on the appeal. Is there anything else I can be of help to the court on that point?
No, thank you.
Grateful. So, in relation to the respondent's notice, I'm down to 6 headings. First, I will identify the scope of the respondent's notice, as there is a procedural issue arising. Secondly, I will set out my submissions in a nutshell. Thirdly, summarise the law in relation to the evidence required in this context. Fourthly, remind the court of the evidence that was before the first tier, and we've already touched upon it, but in relation to the officer point. I'll take you to the Upper Tribunal's decision on the point, and finally address any additional points arising from my learned friend's submissions. But I think So the first point, and I apologise for dealing with procedure, but it does seem the appropriate moment. The scope of the respondent's notice. If I could ask you to turn to the core bundle and page 12. That is the beginning of the respondent's notice. And if we scroll down to section 6 on page 14 of the document, grounds for appeal or for upholding order. The respondent wishes the appeal to court to uphold the order on different or additional grounds because, and there's a reference to the attached ground, singular, of appeal. I'm not going to make too much of an issue about ground being the singular, but it does make sense in a moment. If we move on to section 8, a couple of pages down, towards the bottom of that, page 16, the appeal court upholds, this is what is being sought. The appeal court upholds the order for the following different or additional reasons. Please see attached ground again. if I ask you to turn to page 21, we can see the attached ground. Again, in the heading, it's in the singular. In paragraph numbered 1, I'm in the singular. But what does it actually say in substance? In its decision, the Upper Tribunal's decision at 21 and 22, and it was 21 and 22 where we're looking only at the Section 8 notice, the Upper Tribunal erred in holding the first tier had not been entitled to reach the inferential conclusion on the evidence before it that HMRC officers approved and authorised the issuance of notices to file tax returns in the year 2012-2013 using the parameters of machinery in existence at the time, resulting in the service of a full return on the appellant. And as the court will remember from my opening submissions, paragraphs 21 and 22 dealt with the Upper Tribunal's decision in relation to Section 8. There is no challenge made in respect of the FA 2009 process. So even if you consider the Upper Tribunal reached the wrong decision in relation to the Finance Act 2009 processes, it is not a live issue. Now, that shortcoming was something that HMRC had been aware of for 6 months. Our appeal skeleton argument was submitted in the middle of January. And in paragraph 45 of that skeleton, there was an identical statement to what we find in paragraph 45 of my present skeleton, which is on page 36 of the core bundle. In which we make it perfectly clear by warning HMRC that at that stage they haven't extended the respondent's notice to cover Finance Act 2009.
Sorry, that's a paragraph?
45.
Yeah.
And it's effectively the top of page 36. Mm-hmm. It's noted that HMRC do not seek to challenge the Upper Tribunal's decision. So they don't make the equivalent challenge there. Now, that clear warning did not prompt HMRC to make any application to amend their respondent's notice. And indeed, in their own appeal skeleton, which I believe is dated the 2nd of February 2024, HMRC maintained the approach that the respondent's notice was limited to the Section 8 point. Now, I've tried to compare the wording. I think it's identical, or it's effectively identical, to what is in the replacement skeleton that is currently in the bundles before the court. There are a couple of passing references to penalties. I have to accept that. But I would say that the thrust of the skeleton, and pretty much the thrust of the submissions you've had this afternoon, is consistent with the respondent's notice that it's only the Section 8 part of the Upper Tribunal's decision that HMRC are challenging. Now, would the court like me to go through the skeleton to show why it's not fair to assume that there is challenging Finance Act 2009?
No, thank you.
Okay. So, what we say is HMRC were alerted to the potential shortcomings 6 months ago. Their skeleton argument and their submissions today focus on the more limited ground. And even at this stage, we have not had any application to amend. So I would submit that at this stage in the afternoon, it is now too late to deal with Finance Act 2009. And therefore, the respondent's notice is limited to the Section 8 process and the evidence there. So with that preliminary issue, I want to now move on to the second stage of my submissions, which is the nutshell argument. This was a case where HMRC were clearly on notice in the first tier they were put to strict proof in relation to the involvement of an officer in the Section 8 process. They were expressly told at the first tier case management hearing what they would need to put in their evidence, and they were given 60 days to do so. They simply disregarded the time limit for the production of the relevant
Does it
evidence.
matter? The evidence went in.
Absolutely, yes.
So what does it matter that there was a procedural breach beforehand?
It probably evidences where the misunderstanding in internal communication came. It's not clearly, they failed to produce enough evidence. Now, I accept what Lord Justice Coulson is saying, but the initial breach is not in itself fatal. I wouldn't go so far as to say that. But I'm just giving the background. They were on notice. They then thought they were complying with what Rogers and Shaw said, and they failed. They wait until that decision, and we say that their new and late evidence fell woefully short of what was needed. So in short, we say, for the reasons given by the Upper Tribunal, even with the ability to make reasonable inferences, the first tier could not have reasonably concluded that the processes had sufficient officer oversight. Moving on to stage 3, the case law. And what I'm going to do is to take the court to the 2 cases dealing with Section 8 notices, and then address the FAGE authority my learned friend has relied upon. So the first is a return to Edwards. I don't think I necessarily need to take you to it, but please tell me if you do want to go back to it, because we have seen it. The question in Edwards was whether there was evidence that a notice had been issued. The fundamental difference between Edwards and this case is that the question of officer involvement had not been raised. So the evidence before the first tier was undoubtedly similar to what we've seen in this case, and is summarised by the Upper Tribunal at paragraphs 12 to 14. But again, I'd like to rely on paragraph 56, which you've been taken to. It's page 258 if you want it, which makes it clear that that on its own is insufficient to prove that a notice had been sent. But as my learned friend says, there was other evidence before the first tier that had allowed it to infer that a notice had been sent and received. But at the risk of stating the obvious, there was nothing in that additional evidence in Edwards that addressed the question as to the involvement of the officer in the Section 8 process. The reason it wasn't covered in Edwards is because it wasn't a live issue. Here it was a live issue and therefore needed to be addressed. The guidance in Edwards was then developed by Rogers and Shaw, paragraphs 51 and 52, which you've also seen at page 176 if you want it. But again, the evidence which we have had described is considered to be weak. It's sufficient to show something that might have been sent, sufficient to show that something might have been sent. And that would, as the Upper Tribunal said in Rogers and Shaw, might have been fine if there were no challenge to the validity of the notice. And that's what it clearly says in paragraphs 51 and 52. But this case was one where there was a challenge to the validity of the notice, and where HMRC had clear notice that it was a live challenge. And therefore, following Rogers and Shaw, more is needed to discharge the burden of proof. I will put things as their most charitably. When providing the evidence for this case, either HMRC failed to understand the consequences of Rogers and Shaw, or they failed to recognise and understand the issue that they were having to address. And the final authority I want to refer to is the FAGE case. And it's probably helpful to the court to know that I do not wish to challenge the principles there. They are fully accepted. appropriate inferences may, of course, be drawn. But we say that the inferences drawn by the first tier in this case were inappropriate. And as the Upper Tribunal said, it was merely speculation by the first tier, and this is my words now, filling in the gaps that needed to be filled by the evidence. Those were precisely the same gaps in this case were those that were filled by the evidence in Rogers and Shaw, but were not filled here. And I can conclude my submissions on FAGE by simply referring to what was said at paragraph 114 of that decision, and that's the paragraph we've been looking at. The inferences must be drawn from primary facts. If I can then extend that, it cannot be simple guesswork by the tribunal to make up for the lack of evidence in a respect of a live area of dispute. My next point, which I believe is the fifth point, is looking at the evidence. No, it's the fourth point. Evidence before the first tier. Now, I don't think I need to take you to it, but the case management directions are on page 57 of the supplementary bundle, where it spells out what HMRC needed to do. When they did provide evidence, this is Mrs. McGovern's second supplementary witness statement. It's on page 50 of the supplementary bundle. And the evidence we have seen it briefly starts at paragraph 20. What we can see is that Mrs. McGovern called up some microfiche data. Paragraph 21, remembering this is a response to a challenge that the notices had not been issued by an officer, what Mrs. McGovern says is, for clarification, a microfiche record is maintained in all cases where a notice to complete a tax return is issued automatically by the computer. So we can see that this is the complete opposite of what was being required to be proven. It suggests that the process did not have any officer oversight. And there is nothing in the rest of the evidence going... Sorry.
21.
Paragraph 21. For clarification. So,
yes, where do you get the suggestion that an officer is not involved?
what I'm saying is that HMRC, this evidence was intended to prove the involvement of an officer. That's what it was meant to be doing. It doesn't say that at all. What it says is, I've gone to the...
So because it's not said, you infer the opposite.
Given that what Mrs. McGovern actually said is that a microfiche record is maintained in all cases where a notice is issued automatically by the computer. So she actually says, gives the impression that it was done completely automatically. It certainly doesn't suggest any officer involvement in the process.
Do we know what the words "in line with default HMRC retention of CY6 plus 1" mean?
What I believe it means is that HMRC retain certain documents for the current year, go back, or current 6 years plus 1. I can't quite work out exactly what it means, but it's something along those lines.
Thank you.
But what we do have is Exhibit A11, which is referred to in paragraph 22 of Mrs. McGovern's witness statement. And this is internal guidance. So it's Exhibit A11, page 73. SAM, I believe, is Self-Assessment Manual, section 120060, microfiche record, notice to file guidance. A microfiche record is maintained in all cases where notice to complete a tax return is issued automatically by the computer in line with default HMRC retention CY6+1. Doesn't necessarily advance it any further, but even the exhibit gives no clue as to officer involvement. So if one looks at the question that was at the heart of the appellant's case on this ground, was there sufficient authorization by the officer, because that was how the case was put by the time we'd had Rogers and Shaw, the first tier, the evidence before the first tier said absolutely nothing. And this was a case where HMRC had actually been given a template by Rogers and Shaw as to what they needed to produce. My fifth point is just going through the Upper Tribunal's decision. The arguments I ran in the Upper Tribunal are the same as found at paragraph 52 of our skeleton for this court. The Upper Tribunal's decision starts at paragraph 15, page 68 of the core bundle. In short, I'm just going to ask your lordships to refer to what the Upper Tribunal said, because we rely upon it in full, but I'll just give you a bit of guidance. I'm not going to...
So I'm at page 68 in the core bundle.
Yes, so that should be paragraph 15 of the Upper Tribunal's decision, where it discusses the evidence. Between 16 and 19, the Upper Tribunal compares the evidence in this case with the fuller evidence made available in Rogers and Shaw. And then we get the conclusions at paragraphs 20, 21, and 22. As I said, I wish to rely upon everything there. I'm more than happy to read it out. I'm more than happy to read out my skeleton argument, but I'm sure the court has better things to listen to. I can encouragingly point out that I now just have 2 points to make in response to my learned friend's submissions. The first is the alleged contradiction in the Upper Tribunal's decision, as referred to in paragraph 39 of her skeleton argument, and the conclusions made by the Upper Tribunal in paragraph 48. It's not as stark as my learned friend seeks to suggest. What the Upper Tribunal had said at paragraph 48 were findings made in the context of the section 103 point, as my learned friend accepts. But those are findings which were made with a definition of section 103 which we do not accept. It goes wider than the officer point. So there was no contradiction. And finally, subject to those behind and beside me, on the statute always speaking. As I said, I accept the principle. I refer to it in my submissions this morning. But what it does not permit is outsourcing. It might be something that has evolved over the time, but when a statute says something must be done by an HMRC officer, it must be done by an HMRC officer. I'd submit it's obvious, and I'd submit that it can be inferred also from Rogers and Shaw when they talk about the police constable being, it has to be done by an officer. So statute always speaking does not help. Subject to any questions that the court still has of me.
Thank you very much
I'm
indeed.
grateful, thank you.
Ms. Chowdhury?
You'll be pleased to know, my lady, I intend to finish within 10 minutes.
You have as much time as you need, within reason.
Well, no, hopefully I won't need that much time. There is one point, and I appreciate this is just my reply on the respondent's notice point, but there is one point because this is quite a new point regarding Schedules 36 and FA 2008. And it may be that my learned friend wants to say something on this. Now, I understand this to be taken from paragraph 32 of the Upper Tribunal's decision, which is the reference, it's on page 77.
Yes, paragraph 32. Mm-hmm.
Yes, which refers to it removes the focus on whether an officer, a specified kind of officer, carried out the function in question. Right, and the reason I refer to this is I've done a word search on the decision. There is no reference to authorised officer, the defined term in Schedule 36, in the Upper Tribunal's decision. Now, that is a specific term which carries a specific meaning, and as you can see, it's quite significant in terms of the issue of information notices for Schedule 36. So when as I pointed out this morning, when I say, well, it's not part of HMRC's position that Section 103 overrides requirements of authorisation of an officer for particular tasks, that isn't something which was argued before the Upper Tribunal. Right. I only have 2 points in reply in relation to the respondent's notice point. And the first one, and I'm afraid I have caused some confusion by referring to the FTT's decision in relation to the penalty notices. Just to be clear, the respondent's notice challenge is in relation to only the Section 8 notice. Okay. And the reason we're not seeking to uphold the FTT's decision in relation to the penalty notices is you will have recalled that it's paragraph 145 on page 155 where there's a reference to HMRC designing computer programs. Now, that's not something HMRC, as far as I'm aware, we're advancing. I didn't argue the case before the FTT, and it's not a finding which we are seeking to defend either. And so we are content for the respondent's notice point to only deal with the evidence in relation to the Section 8 notice. Okay. Actually,
And the effect of that on the case as a whole?
Well, it's, I think, okay, whether or not the Section 8 notice was valid.
Yes,
And
but not pursuing the penalty notices in that regard. What effect does that have?
well, we would hope it has no effect because you're going to be with me on Section 103. And that may well be the answer. That's it.
Yes, but I think my lady's question
Yes.
goes to the respondent's notice point.
Indeed.
By my calculation, this is not the first and last night of the show, but the third night of the show. This is the third time these facts of unparalleled dullness are being paraded before a court or tribunal, which is the complete opposite of farce. So my lady's question is, what is the effect on the respondent's notice point if it's limited to Section 8?
Well, we would say that the notice to file was valid and that there was sufficient evidence and that everything flows from there. And I completely agree, my lord, that the facts are of dullness, which is why I have tried to deal with the respondent's notice point at speed.
That's speaking personally, of course.
The only other point I had in reply was this reference to this question about how Mr McGovern had referred to the microfiche data and how it showed the return having been issued automatically by a computer. I think you have my point on that. That no matter, even if you refer to something being issued automatically by a computer, it's still programmed by someone, either an officer or with the authority of an officer. And that leads to the last point on whether or not statute is always speaking. Now, my learned friend says it can't cover outsourcing. And we would say that the words of Section 8 are wide enough to cover outsourcing. And indeed, that is how they were understood until challenges started to crop up in the tribunal on a regular basis. Again, I have shaking and nodding heads behind me, so unless there is anything further.
Thank you very much indeed. And I think that draws all the responses and replies to a close. Thank you very much indeed to everyone both in the front row and behind, for preparing this case for us. First of all, you will be fully aware, I'm sure, of the way in which these matters are dealt with in this court. We will circulate our draft judgments when they're ready for only typographical errors to be noted. No re-argument, thank you. They will also be circulated to those whose emails have been provided. If you wish to have the draft sent to more people than those whose details have been provided, please ask. Please don't just do it. There may be all sorts of consequences if you try yourself without authority to widen the pool, put it that way. As you'll also know, the way in which these matters are dealt with in this court, once those drafts have been finalised, we will also be looking for all consequential matters to be agreed. We hope that you will be able to agree an order. If you can't, you'll be given a date and a time by which to put in written submissions. Please make them short, and we will decide on the basis of your written submissions. And the hand down, as you will also know, takes place electronically, and you won't be asked to return to this court. Thank you very much indeed.